Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. It is Monday morning, April 7th. We have been up since before the sun came up, waiting for the orders list to come out from the United States Supreme Court. It is here. Now, the thing that we've all been waiting for is not here, but there is a lot to digest from this orders list, which is why we decided we're going to do this video today, get you educated about a few things that are happening to your Second Amendment rights. So today, let's spend a few minutes and let's talk about bad news and no news from the Supreme Court today. Okay, America, we're talking about the same old Groundhog's Day that me and many people in this sphere have had over the last several Mondays now, as we anxiously await for the orders list to drop from the United States Supreme Court. It comes out Mondays at 9:30 a.m. on the East Coast, which means 6:30 out here on the left coast. Now, obviously, we have been waiting anxiously for both Snope v. Brown and Ocean State Tactical to find out if they will be accepted. And one would think after 8 conferences we would have an answer by now. But no. The Supreme Court is going to keep us waiting. There was absolutely no news on Snope v. Brown or Ocean State Tactical at all today. Which sometimes no news is good news here, but also no news is bad news as well, because we continue on to another conference. We're going to circle back on that case, but at the current time, as of Monday, April 7th, we do not know what the heck is going to happen with Snope v. Brown nor Ocean State Tactical versus Rhode Island. But I do want to talk about 2 other cases that were addressed today on the orders list, one of which is a little disappointing, but not too surprising. The other one is not surprising at all, but is disappointing. I will explain both. The first one I want to talk to you about, and we've talked about this case right here, is a really, really important Second Amendment issue case, is Antonyuk v. James. This is a challenge to New York's Concealed Carry Improvement Act, or essentially a big, gigantic middle finger that the state of New York threw to the United States Supreme Court following the Bruin decision. Now, in addition to them just basically removing their one subjective criteria from concealed carrying licensing and supplanting it with even perhaps a more subjective criteria, one of the other big issues to be decided in Antonyuk v. James is what is really the proper historical period of time to be looking at when we're trying to determine the constitutionality of gun control regulations? Is it the founding era? Is it the Reconstruction era? Is it a combination of the two? And if so, what emphasis should be placed where? Because one of the things that the lower courts have done in a lot of cases, including in Antonyuk v. James, where they found no problem with all of New York's new subjective criterias that were injected into the concealed carrying licensing, as well as all of the sensitive places that they passed, is they relied heavily on Reconstruction era history. And if you rely almost exclusively on that, yeah, you can justify a lot more things than if you are dependent upon founding era history. This case was going to be a huge case not only for those reasons, but again, this is a state that basically threw a big, gigantic middle finger to the United States Supreme Court, and we had hoped that the Supreme Court would prove that they have some semblance of a backbone. But no, this petition was rejected, and it was rejected in relatively short order. You see, this case was just on its second conference when the Supreme Court rejected its petition. Now, is this surprising that they rejected it? Not really, and here's why. Because this case is in an interlocutory phase, okay? The petitioners here had moved for injunctions. They got a few, but not nearly as many as they wanted. They appealed to the Court of Appeals. They upheld the trial court's decision, and now they had appealed further to the United States Supreme Court. So this is a case that basically would have come to the United States Supreme Court in a phase where everyone's still arguing about what injunctions should be in place or not. And as we know, for those of you who geek out on this channel, the Supreme Court is not real keen on taking cases in an interlocutory fashion. The rejection of Gray v. Jennings, a case earlier this year by the United States Supreme Court, probably told us all we needed to know about what was going to happen in Antonyuk v. James. But nonetheless, it is an incredibly frustrating ruling, especially for the citizens of New York who will continue to live under the purview of this unconstitutional law for the foreseeable future. This is not the last we're going to hear of this case, though. I can assure you that once this case is argued on the merits, it will come back to the United States Supreme Court. But while that denial is not necessarily the big surprise, what was the big surprise is the fact that we saw no dissenting opinion at all. And if ever there was a case where you would think that Justice Thomas or Justice Alito would throw some shade on things, it would have been the rejection of this Antonyuk case. Why is that? Well, because as I mentioned earlier, this case really stems from a state just basically telling the Supreme Court to go F itself. And if ever there were two justices that don't seem to be big fans of that, that would be Justice Thomas and Justice Alito. However, neither of them authored any dissenting opinion at all. As a matter of fact, on today's orders list, there was no additional opinions attached to it at all. That is all just straight rulings. And by the way, for those of you who think, oh, this must be some big fancy document that the Supreme Court spits out every Monday, no, here's what it looks like, okay? And as you can see, I don't think they've changed the format of this document in about 50 or 60 years now. But what does no dissenting opinion tell us about Antonyuk v. James? Maybe nothing. Maybe it tells us that Justice Alito and Justice Thomas are just getting tired and beaten down over this. Or maybe it tells us that, in fact, they already are going to get what they want in the way of a Second Amendment issue. And that would be, of course, acceptance by the United States Supreme Court in the matter of Snope v. Brown and Ocean State Tactical versus Rhode Island. And I know there are people who disagree with this. But I do believe that if these petitions were going to be rejected, they would have been rejected at least 3 or 4 conferences ago. There has been ample time for this issue to be discussed. The issue has been absolutely thoroughly briefed by both sides. And if Justice Thomas or Justice Alito wanted to author a dissenting opinion, they have had more than enough time to do so. So this is definitely a political hot potato, much like the Dobbs case, and it now moves on to its 9th conference. Now, the final case I want to tell you about is a case that got GVR'd today. It's the case of Gray versus the United States. This is like the 184th challenge to 18 United States Code Section 922G1, which says if you've been convicted of a felony, you don't get to possess firearms anymore. Now, this is a case that comes to us out of the 11th Circuit Court of Appeals. And in denying Gray's challenge, constitutional challenge to 18 U.S.C. 922G1, the court had relied heavily on 2 cases. The first is a case from way back in 2010 called Rozier. Now, Rozier had found 18 United States Code 922G1 to be constitutional, but had done so using the old 2-part balancing test. Fast forward about 14 years later, there was a case called Dubois. That case upheld 18 United States Code Section 922G1, basically saying, hey, listen, Bruin didn't overturn Rozier. Rozier is still good law. What Gray is challenging here is hey, have we actually applied the correct constitutional standards to 18 U.S.C. 922G1? And is it possible that Rozier was in fact abrogated by Bruin? It's a very important decision, a decision that actually needs to be made. But what the court has done here is they have GVR'd it, which means they have granted the review, they have vacated the ruling of the 11th Circuit, and they have remanded it back for holdings consistent with Rahimi. But here's the thing. Dubois, one of the cases already decided, was decided post-Rahimi. And let us also remember that we have seen many other cases go back to lower courts subject to the holdings of Rahimi to find what? Absolutely no change at all. So is this the proverbial kick the can down the road? In all likelihood, it is exactly that. So in summary, Snope v. Brown, no answer. Ocean State Tactical versus Rhode Island, no answer. Antonyuk v. James, denied. Gray versus United States, GVR'd. Now listen, I don't know when exactly Snope and Ocean State are going to be rescheduled for conference. As of the recording of this video, they had not updated the docket. I don't believe there is a conference scheduled for this Friday, so we may be in a 2-week holding pattern. We should all be used to that by now. Listen, we're going to go ahead and link up the orders list down below so you guys can geek out on it for yourself. Don't have to take our word for it. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, cool. Just click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that's down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.